And it says we have for review the Department of Health and Rehab, and actually second DCA is beneficial for you. This would apply to Ken. This would apply to Ralph and anybody in Florida in the middle, in the Florida, in the Central Florida area. If you're in the 13th, 6th, or 12th Judicial Circuit, in which the district court upheld the dismissal of paternity and child support action against an out-of-state punitive father on the grounds the court lacked personal jurisdiction. That goes in. But here's this, and the reason I wanted to get into this case, and they're going to go into a whole lot of semantics, and I'm going to AC's docket first, real quick. You all still see the you see a case text, or do you see the big one? Let me share the right one with you all. Let me show y'all something. Oh, I see what you all are looking at. That's the one I want y'all to look at. Y'all see the one that says case text?
Yeah.
Yes,
Okay.
sir.
Yeah.
That's the one, same case, but I did one when I did the highlights in it, because the question that you want to find out. Control F.
Taught. Oh boy. I've seen that word so many times.
That's where I'm at for damages.
Okay, but how do it's how do you address the issue? And the other part that I tell people often is focus on what is the legal issue. Contends no torturous conduct could have occurred because no duty had been placed on him. They're going to break that down in this case as well. Forget the other part about him not being in the state. But what this case is going to do is show people, is give you all at least hopefully a underlying understanding. Until you have an obligation, you don't have an obligation. When we get in there, a lot of times we talk about everything except what was my obligation, to what rights would you have as you were there. Because if you're a father, depending on what state you're in, like in Florida, mothers and fathers have equal access to the child. Did you raise any of these issues? Was it a purely an administrative issue? Or like my cases were judicial. That's why the procedural aspect of it matters. If your case is administrative, did the administrative process that your state used violate a well-established protection? If so, how do you go about reversing that issue? It's the questions that we ask that are directly related to the order, ORDER. What does your order say? How did they get the order? Was it by default?
It's funny you brought that up when you talked about my case the other day, and we went through all these things, and I'll be honest with you, everything you're saying is true. Everything you're saying is like it's the same thing I went through.
What the court, I'm just going with what the court said. Look right here. Read that part right there for me. The green part. Fact. LK, read if you can. Ken, read the that orange, and then Ralph, you read the green. Ken, read the orange.
All right. Right contends that no tortions could have occurred because on duty had yet been placed on him. He argues that until paternity is adjudicated in the court, he is under no duty to pay child support, and this committed no tort.
Yeah, you must be on the phone.
Yeah, you got we agreed to saddle a defendant with the burden of child support before paternity, and as established would be both illogical and unjust.
You see that? To saddle a defendant with the burden of child support before paternity has been established would be both illogical and unjust. A court cannot, as an initial matter, assume that a defendant is the father of a child so they can adjudicate the matter of non-support, and upon finding non-support, use such tortious conduct as the basis of jurisdiction to adjudicate paternity. That's not Greg. That's the case law. But what they're telling you is, think about this. And then they come back and say, well, they find this to be persuasive. So this must have come out of the Florida Supreme Court. See something. Yep, Florida Supreme Court. So the Florida Supreme Court was trying to settle a conflict between two different DCAs. Because they said we find it persuasive, meaning not binding. Several states, and this is always important, persuasive law means they can consider it. Binding means they must follow it. Y'all get that?
Right.
I think you might have seen that also when it came to that Holmgren case somewhere, persuasive versus binding. But anyway, several states have analyzed this type of situation under similar long-arm statutes, have reached the same conclusion. And they give you states. These courts reason that failure to provide child support is only an ancillary issue in the paternity proceeding, with the primary issue being paternity itself, as did the second district. We accept this reason.
Wow, that is crazy.
So
imagine these cases have been brought before the Florida Supreme Court, and yet they still operate under apparatus agenda, changing and adding what they want outside the guidelines of child support. What is that? I'm telling you.
Maybe we got to go back to what we did about not in the show before when we talked about affirmative defenses. When you walk in there, if you don't raise the affirmative defense that, hey, I don't have a responsibility yet, we get in there to talk about everything else. But,
yeah.
Hey, wait a minute. Whoa, partner. You haven't determined meritoriously that I'm obligated to do shit.
Yeah, because the burden of proof is on them, but they're operating on presumption.
But what the presumption doesn't work. But if you don't object to the presumption, you acquiesce to the presumption.
That's right.
That's what happened to me.
That's right.
Focus on the law, not on the feelings.
The feelings and the behaviors.
Now, here you go. We recognize, okay, everybody's in. We recognize that an equal number of states have addressed this issue, have adopted the reasoning advocated by HRS, as the Health and Human Services used to be. That's DOR today. That used to be what it was back in the day. These cases hold that the allegation of failure to provide support is sufficient to constitute a quote-unquote torturous act within the meaning of their prospective long-arm statute.